Thank you, Mark, for that interesting introduction. And thank you. Thank you all for returning from the break. You will not be disappointed. I have for you breaking news from the Court of Appeal. Yesterday afternoon, when I was preparing my remarks for today, the Court of Appeal released a decision that overturned one of the cases that I referred to in my paper. So, had to rejig, improvise a little, but the case I'm referring to is called Peel Law Association and Peters. The facts of the case are pretty straightforward. There were a couple of male black lawyers that were in the Brampton courthouse in the lawyers' lounge, and they complained to the tribunal, the Human Rights Tribunal, because they were asked for ID in the lounge. The librarian said that she routinely asked lawyers for ID because only lawyers were allowed to be in that area, but the complainants said that they had been singled out and that she was rude to them. So the tribunal, in hearing the case, found that there was discrimination, and the divisional court then heard the case, and they overturned the tribunal's decision and found that discrimination had not been established. The divisional court said it was not enough for the applicants to say that they were black and they were asked for ID, but they had to establish a prima facie case of discrimination. They had to establish a causal link or a connection between the protected ground of race and what happened to them. And the divisional court found that they had not done that, and essentially that the Human Rights Tribunal had reversed the burden of proof by requiring the librarian to disprove a negative, to prove that she hadn't discriminated. Then, yesterday, the Court of Appeal reversed that decision, and they restored the Human Rights Tribunal decision, finding that there was discrimination. So the Court of Appeal said that the divisional court had applied the wrong test for prima facie case. In fact, the Court of Appeal said there wasn't a need for a causal connection or a causal nexus, to use their words, but rather the question was whether race was a factor in what had happened to the men in the library. And the Court of Appeal also found that there was no reversal of the burden of proof, but rather what happened was the librarian had an evidentiary or tactical obligation to call evidence of why she did what she did, otherwise she would lose. In any event, the Court of Appeal said that the whole question of prima facie case wasn't really relevant in this case because all the evidence had been called, so what the tribunal was doing was assessing all of the evidence to determine whether discrimination had been established. And the question of prima facie case is more important when you're arguing that you shouldn't even have to call any evidence because the applicant didn't meet their burden to require you to respond. The Court of Appeal also was critical of the divisional court for not showing enough deference or not deferring to the findings of fact of the Human Rights Tribunal. So, you can just ignore that part of my paper. It's all wrong now. This is why it's hard to get a straight answer from lawyers sometimes, because the law changes. Just when you think you know what's going on, it changes. So I'd like to thank Heather Power, who wrote my paper and did an excellent job. She's one of our fantastic students. And I recommend that you look at the paper, but maybe just skim over that Peters and Peel Law Association part. I'm also going to tell you about some changes to the Human Rights Code that were implemented a few years ago. And recently, a report was released. It's sometimes referred to as the Pinto report because it was written by a man named Andrew Pinto that assessed those changes to the human rights system. So as you know, we now have a direct access model, so people complain directly to the tribunal rather than complaining to the Human Rights Commission, which then refers it to the tribunal. This change was intended to speed things up, and I think it has done that. We've gone from, before there was an average of about 48 months from the time a complaint was filed until it was resolved, and now it's about half that. It's about 23 months. So that is an improvement. And there's still room to improve further. Pinto made 34 recommendations in his report, which was released in November. And at this stage, they are just that. They're recommendations. They haven't been acted on by the government. Evidently, they've been too busy wiping hard drives and other such things to get around to the Human Rights Code. So this is the part of the presentation where I'm going to attempt to use PowerPoint. So I've got a few slides to show you. If you could just put those up there, please. Excellent. So we are going to focus on a few of the recommendations that are most significant for employers. We're not going to go through all 34 today, thankfully. So one of the recommendations was to reduce the inappropriate naming of personal respondents. Now, many of you may have seen this on human rights complaints. You may have even been named. HR professionals are sometimes named on these complaints. And while you can generally get inappropriate respondents taken off complaints, it would be much, much better if people weren't named at all, because obviously it's very stressful and it's another hurdle for the respondents to have to go through in responding to the complaint. Another recommendation that would help employers would be to establish a better protocol for the delivery of applications to big employers in particular. Sometimes they get lost. I'm sure this doesn't happen to any of you, but sometimes they end up on the wrong person's desk, and it can take a while before we, as lawyers, end up receiving them, which means that there's less time to respond. So it would be helpful if there were a procedure to ensure the right people get those applications. Next, Pinto recommended that mediations should occur as early as possible in the process. About 65% of the cases are resolved at mediation, so a fairly significant number. On average, that occurs about 9 months after the application's filed. And the thinking is that if they could get the mediation to occur even sooner, people may be less entrenched in their positions and more open to resolving it. Recommendation number 7 was that mediation settlements be published. Now, just so you're clear, they're not talking about publishing the names of the parties, but rather just publishing the results of the settlement in an anonymous way. The thinking is that it would help people to assess settlements. It would help especially self-represented people to assess whether or not a deal is a good deal and to maybe have more realistic expectations of what they're going to get. I'm not sure whether that would actually be the case if this recommendation were implemented, because settlements depend on many things, but I don't know how you would be able to, reading the settlement, assess, how likely you'd be able to prove certain facts or that sort of thing. So I'm not sure that it would really provide much educational value, but nonetheless, it's an interesting idea. Recommendation number 8 is for the tribunal to promote active adjudication in its hearings. What is active adjudication, you may ask? Section 43 of the Code gives the tribunal the power to do a number of things to streamline hearings. It can narrow the issues in dispute. The tribunal chair could actually take over questioning a witness. It could determine the order in which evidence would be presented, or even whether evidence should be presented on a certain point at all. So far, the tribunal has used this power very sparingly, but in the future, it might use it a little more aggressively to try to shorten some of the hearings and get to a decision sooner. You'll love the next one. The recommendation that the quantum of monetary damages should be increased significantly. So what they're referring to here are the damages for mental distress or hurt feelings as a result of discrimination. There used to be a cap of $10,000 on those damages. That cap was removed with the changes a few years ago, and damage awards have been gradually creeping upwards. They tend to be in the range of $5,000 to $15,000. But some cases, particularly if there's been serious discrimination or harassment, are awarding $25,000, $30,000, $40,000 in damages. So from my perspective, the quantum of damages has indeed increased, and I'm not sure that there's really a need to increase it further. The next recommendation is for the tribunal to explain why it didn't award a public interest remedy in a case where it found discrimination. So a public interest remedy is a remedy that is intended to correct the reason why the discrimination arose, like human rights training or to post a human rights policy, that sort of thing. And if this recommendation is implemented, then I think you can expect that there would be more public interest remedies awarded, more employers ordered to develop human rights policies, and that sort of thing. The next recommendation was to reinstate the duty counsel service at mediation. For a period of time, the Human Rights Legal Support Center, which represents some applicants, was available at mediations to assist applicants, not necessarily to represent them, but just to give them advice on assessing the possibility of settlement. And that seemed to be quite helpful because a lot of self-represented people have very unrealistic expectations of what they might get as a settlement. Nevertheless, that was discontinued because there wasn't enough money to extend it to past Toronto. So if everybody in the province couldn't get it, then Toronto wasn't going to get it either. The last recommendation is to investigate the merits of a cost regime. Now, as you may be aware, there's no costs awarded on human rights complaints right now. Even if it's a totally frivolous, baseless complaint, there's no ability for the tribunal to award the costs to the winner. Now, Pinto recommended that they study this. He didn't actually recommend that a cost systems be adopted, but just that there would be a further study, a further report. So we will see if that happens or not. All right, thank you. Last year, the code was also amended to add gender identity and gender expression as prohibited grounds of discrimination. Now, if you're not sure what gender identity and gender expression mean, you're not alone. They're not defined in the code. In fact, the Commission is now holding a consultation about what these terms mean. One might have expected that they would have done that before adding it to the code, but not the way things work. So far we have draft working definitions from the Commission. And gender identity is thought to be one's deeply felt internal and individual experience of gender. So what you perceive your gender to be, which may or may not correspond with your birth gender or your biological gender. Gender expression, on the other hand, is how that perception of gender is expressed to others. So it would be things like your hairstyle, the clothes you wear, that sort of thing. Your behavior, how you express your gender to others. Now, to give you an idea of how these grounds might come up in a human rights application, there's a recent case called Vander Putten and Sadeco Packaging. Now, this case the application was actually filed before these grounds were added to the code. But the tribunal found it could consider them anyway because it found that it was sex discrimination. So the tribunal talked about these new grounds that had been added, but it doesn't appear that they really would have changed the analysis much. The applicant in this case was a difficult employee. Tony was hired in 2003 as a laborer in a manufacturing facility. He had a number of incidents on his discipline record, and was eventually dismissed in 2006 after a conflict with another employee. Inexplicably, they hired him back the next year. If you learn one thing at this seminar, learn that. If you manage to get rid of that difficult employee without a human rights complaint, without a lawsuit, don't hire him back the next year. But anyway, Sadeko did that. And not surprisingly, he started to get into trouble pretty quickly after they hired him. He was suspended for a week for throwing a wooden pallet at another employee. He received a number of warnings. Then he began to go through hormone therapy. So Tony became Maria. She started to dress as a woman at work. She wore makeup. She began to develop womanly attributes. But the company would not let her change in the women's change room or use the women's bathroom until she was fully biologically a woman. So she was using the men's change room. As you can imagine, that caused some problems. There was a lot of talking going on. There was a little bit of pushing and name-calling and that sort of thing. But Maria was no innocent in this either. She often would provoke other employees by asking them if they liked her outfit, if they wanted to look at her boobies, that sort of thing, which some of the men in the change room didn't take too kindly to. Management tried to intervene. They investigated a number of her complaints of harassment, but they found that generally she was the one who had instigated it. They also held a meeting with employees. They drafted a code of conduct to prohibit discrimination. Nevertheless, the problems continued. In one incident, the applicant was going around asking female employees about their bodily functions, about their sexual experiences, and that sort of thing, which again, people did not take too kindly to. Then, shortly thereafter, she had another dust-up with an employee. The employer investigated and found that she had started it by throwing skids around, and so they decided to dismiss her. She filed a human rights complaint, and the tribunal found, not surprisingly, that she was subject to harassment. Now, as you know, employers are liable for harassment if they don't take reasonable steps to prevent it and investigate it. The tribunal here found that the investigations were not reasonable because the employer went in with the perspective that the problems were being caused by the applicant. And sometimes they were, but the employer assumed that they always were. The tribunal also found that it was discrimination to require her to continue using the male's change room. The employer hadn't established that it would be undue hardship to make some other arrangement for her to change. Finally, the tribunal found that her gender was a factor in the dismissal, even if it wasn't the only factor. The dismissal was based on the conclusion that she was causing conflict at work. But the HRTO found that sometimes the conflicts were caused by the harassment. So the harassment triggered the applicant to act out and create even more conflict. Therefore, the tribunal found that it was linked to gender. Remember, these new grounds weren't in the code then. So it was linked to gender. Therefore, there was an element of discrimination in the termination. Excuse me. So the applicant was awarded $22,000 in general damages. She did not seek reinstatement, but an 8-month notice period was awarded, and as well public interest remedies of developing a human rights policy and training management were ordered. One last case that I'm going to tell you about is called Fair and Hamilton Wentworth District School Board. This case it's an accommodation case, but it's significant not because of what the employer did or didn't do, but because of the remedy that was awarded. In this case, the tribunal awarded about $500,000 in damages. Most of that was back pay for about 9.5 years from the date when the employee was terminated to the date when the tribunal issued its decision. So it's important that that delay was not due to any of the parties' fault, but rather just because that's how long it was taking for it first to go through that old commission process and then to be processed by the tribunal to a final decision. Notwithstanding that 9.5-year delay, the tribunal found that reinstatement was the appropriate remedy, and it ordered back pay and pension contributions, etc., for the last 9.5 years. The tribunal accepted that during that time, she wasn't able to find another full-time job, and the tribunal ordered $30,000 for the injury to her dignity. So that's those damage awards that Pinto thinks needs to be increased. This decision is being judicially reviewed, so next year it may be different, much like the case I spoke about earlier, but still it does serve as a reminder. Accommodation cases are very difficult. It's a judgment call, and if you make the wrong judgment, it can be costly. Thank you.